Good morning. My name is Giselle Contreras, and I am representing the defendant, Daniel Smith. Now, Mr. Smith is filing a motion to suppress approximately 2 months of historical cell site location information, roughly over 5,000 pages of related provider records, and real-time pings that place Mr. Smith at the Miami airport on the day he was arrested. Now, under Carpenter v. United States, the cell site location history must be suppressed as it is constituted as a Fourth Amendment search and it requires a warrant. Now, the real-time pings should also be suppressed unless the state proves tracking was sufficient under SIMS or justified by exigent circumstances, which we will define later on. So let's discuss the relevant facts. Detective Garcia obtained the cell site location information of Mr. Smith from the months of July to August of 2023. Then the state will be providing or seeks to provide 5,000 pages of related provider records. Now, all of this was done through subpoena and not through a warrant, which is the predominant issue in this case. So, the officers later used the real-time pings to be able to find and locate Mr. Smith at the Miami airport and attempt to depart to Cuba. Now, the one specific detail in this is that the time and the number of pings is not disclosed in the evidence. This is relevant later on when we get into the argument. But first, I want to present to you the legal standard. Obviously, this is a Fourth Amendment issue, which deals with unlawful and unreasonable searches and seizures. Now, I think the one thing that we can agree on is any warrantless search is presumptively unreasonable, right? Especially in circumstances like these where there is evidence that is required in order to disprove the need of a warrant. So, under Carpenter v. United States, 7 days of cell site location information triggered these protections and essentially stated that under the Fourth Amendment, this is a search. Now, in contrast to our case, 2 months is roughly 9 times that amount. Now, the court also held that compulsory process that the court orders that the government admits is still not sufficient to replace a warrant. Then I also want to address a brief Texas law in Article 3823, which explicitly states that any evidence that is gathered unlawfully must be suppressed in court. So, under State v. Daughtry, the Criminal Court of Appeals held that Texas recognizes also no inevitable discovery exception. And in addition, I wanted to briefly put out that the good faith exception, an officer objectively relies on a warrant issued by a neutral magistrate. Obviously, that's not what happened in this case. The other factor is exigency, which we will discuss. So I want to start by saying the historical records. Carpenter has worse facts than the government. So, like I said before, Carpenter was triggered 7 days in. This has been going on for 2 months, 9 times roughly, right? As I said before. In addition, with less process, no warrant, just a subpoena. That's not sufficient. So, then, since the warrant was never issued, no officer could have relied on good faith. And the Texas law forecloses inevitable discovery. So on the subpoena records, suppression follows directly from Carpenter's holding. So in terms of the cell site location information and the provider records, those must be suppressed. Because as we stated before, the Fourth Amendment, right, that protects against unlawful searches and seizures. As a functioning member of society, we are going to have to use our cellular devices. That is an inevitable reality. So if we, as citizens, state that the third-party doctrine, which was discussed in Carpenter, is still valid, that discloses all of our whereabouts. Our expectation of privacy goes out the window because at this point, where we eat, where we work, where we pray, where we live is all now public information because of this third-party doctrine. It gives an insight into all of our everyday intimate movements and whereabouts, right? So now we're going to move on to the real-time pings. So the contrast that I would like to make is in Sims v. State, the Court of Criminal Appeals held that fewer than 5 pings over 3 hours did not constitute as a search, because how is that going to give you a true view into where that person is or what they're doing? Now, in contrast to our case, there is no information on the duration or the number of pings. So now we are kind of comparing assumption to fact. So these two things cannot be compared. Without those facts, the court cannot simply assume that the surveillance falls within the narrow landing of Sims v. State, right? In the narrow landing of Sims, that gives a specific number of days, and the amount of pings cannot be compared to no evidence, no data, no numbers, no time, no anything at all. So the exigency is the one thing I wanted to also briefly touch on. Exigency applies to the pursuit of a fleeing suspect, which is covered in Carpenter, which would be the only exception of having a warrantless search. But I would like to add that there is no evidence of the officers even making an attempt. There is no evidence as to how did they know that he was going to go to the Miami airport? How long did they know of this supposed attempt to flee to Cuba? If we have this gray area where there is no information or no evidence, it leaves space to ask, why didn't we obtain a warrant? This is obviously a very important thing, right? We need to pursue this person, but why did we not take the time to obtain the warrant if we have no data whatsoever of how long he was at the airport, how long he was planning to leave? There is no evidence on that. Therefore, we must ask the question and pose the question, why are we not utilizing the process intended to invoke these Fourth Amendment rights to the American people, right? So the counter, likely, as I said before, will be compared to Sims v. State for the real-time pings, and then the exigency principle for Carpenter. As I said before, there is a massive contrast. Fact cannot be replaced with an assumption. The fact is, 5 hours, 3 pings is not equivalent to no data at all. And in the same manner, the exigency, we don't have enough data. Why was there no warrant? All we know right now is that the CSLI records were obtained for approximately 2 months. 7 days was the trigger in Carpenter. So here we have a massive numerical difference, which really cannot be argued. So that would be my rebuttal as to those 2 points. Sims, Carpenter, the protections are triggered. There isn't sufficient data. So therefore, I would, for those reasons, Your Honor, Mr. Smith respectfully requests that the court suppress the historical CSLI and related provider records obtained without a warrant. He further requests the suppression of real-time pings unless the state establishes that the tracking was sufficiently limited under Sims or justified by exigent circumstances. Thank you.